Your Lordship, Lordship heard this matter for some time yesterday, Your Lordship. This arises out of a departmental trap case, whereafter a departmental proceeding was initiated against the petitioner and which culminated in a punishment of compulsory retirement. Now, Your Lordship had put a query: what are the legal infirmities in the departmental proceeding? What are the legal infirmities in the departmental proceeding? So the first ground is that the departmental trap case did not follow the vigilance manual, railway vigilance manual, which was in force at that particular time, in as much as Rule 704 and 705, which clearly stipulates that a independent 704 and 705.
What is that?
I've given a list of judgment, Your Lordship. That rule is quoted in that particular judgment. 2008 3 SCC 484.
Where is the book?
The judgment starts from page 484. The relevant is at 489, where those two rules have been quoted.
What? Read.
Rule 704, traps. When laying a trap, the following important points have to be kept in view. Two or more independent witnesses must hear the conversation, which should establish that the money was being passed as illegal gratification to meet the defense that the money was actually received as a loan or something else if put up by the accused. However, in the present case, the shadow witness, Braj Kishore, was never examined in the departmental proceeding. One Mr. Braj Kishore, who was shadow witness, who...
What is his name?
Braj Kishore. Braj Kishore.
What was the post held by him?
First of all the witnesses and even the decoy was employed in the vigilance department, which also violates that particular rule.
Don't jump, sir. Once you have arguing one particular point, you complete that. What was the post held by Braj Kishore?
Braj Kishore was Khalasi Mahaprabandhak, Vigilance Gorakhpur.
He has not been?
He has not been examined.
He has been cited as witness?
He has been cited as witness, but he has not been examined.
His statement was recorded on the date of trap, my lord.
Why he has not been examined?
But subsequently, he died before, in course of, he died, therefore he could not be examined. But the witnesses are there who prove
Other witnesses?
his statement. Yes, my lord.
During the course of the inquiry, he died?
Yes, my lord.
Now, all the other witnesses, they never uttered a single utterance. They overheard the conversation, whether this money was for illegal gratification or as contended by the petitioner that it was...
Correct, but the person who has giving the money,
yes,
he is disputing that it is an illegal gratification.
But as per...
This evidence is required, no? Otherwise, you have to prove what is the grudge against you and the giver, money giver.
That is one another point. If we read the rule further, Your Lordship, the person should not be knowing the person who is being trapped. However, in this present case, it was our contention that we already knew that person decoy from earlier period of time, and therefore...
Where is that? He should not be known. He should be stranger. I don't think such a...
On the date of trap itself, my lords, the statement of the petitioner was recorded in presence of witnesses, several witnesses.
He has admitted.
Yes, yes, he admitted, and he simply said that on the at the instance of Dr. Sahab, I have received the money. That he said. But subsequently, on the next very day, he said, no, I paid him the amount for ghee. I had taken ghee from Odi, and I paid that amount. Subsequent, the next very day.
Thereafter, further Rule D, Your Lordship. Witnesses selected should be responsible witness who have not appeared as witnesses in earlier cases of department or the police are men of status considering the status of the accused.
Who are repeatedly cited as witness?
They were all employees of the vigilance department. They were not independent witnesses.
No, that is not the issue here. The witnesses selected should be responsible witnesses who have not been appeared as a witness in earlier cases. You show us in earlier cases so and so has been cited as witness.
what I'm submitting is they were all witnesses who were working in the vigilance department at that point of time. And as such,
Sir, it is a trap case, sir. It is a trap case. You can't say that.
and
You can't take the stand ghee
then
because the ghee version has been reversed by the complainant.
and then Rule 705, which is starts at the bottom of the page,
What is this?
and then next page, subsection B,
Subclause?
subclause B of 490, page 490.
What is this?
Here again, I'm emphasizing on that fact, Your Lordship, where 6-7 lines from the top, Your Lordship. The independent witnesses will take up position at such a place where from they can see the transaction and also hear the conversation between the decoy and delinquent, with a view to satisfy themselves that the money was demanded, given and accepted as bribe, a fact to which they will be deposing in the departmental proceeding at a later date. But this,
No, this could have been appreciated provided bribe giver has stated that he, in the guise of purchasing ghee, I have given him. On the other hand, he is giving.
no, but our condition
That is the reason.
and became,
What is the grudge between you and the bribe giver?
there was no grudge as such, we have not.
Then we have to accept his version.
But then these safeguards are there for the delinquent and they must be followed in by the.
Sorry, sir.
So this is my first submission. My second submission is that if Your Lordship will look into the order of punishment, Your Lordship, which is Annexure 4 at page 56. Complete non-speaking order, Your Lordship.
56.
Page 56, Annexure 4, page 56, 5656, Annexure 4. This is the order of punishment, a complete non-speaking order, Your Lordship, which shows no application of mind at all by the disciplinary authority.
Page 56 and 57.
Yes, Your Lordship. My second show cause is just before that. I've submitted a detailed explanation to all the charges in the inquiry, but it was.
The appellate authority's order?
Appellate authority's order is at Annexure 8, page 66. That is also non-speaking order without any consideration. Just in one sentence, they have not even considered the grounds raised in the memo of appeal. Page 63, Your Lordship.
Mind the matter.
Sorry, page 66.
Which department? You said railway. The Railway Act.
I have a copy of the rules.
छोड़ दो. Where is the appellate authority order?
Page 66.
66 is disciplinary authority.
The order of Chief Medical Officer.
Is it appellate authority order or disciplinary authority order? Yes, Mr.
Hello, this is,
Take page 66.
yes, my lord, this is appellate authority.
Correct. Now it read Rule 22. Whether is there any compliance to Rule 22 or not? Sub Rule 2 of Rule 22, there is no consideration. What is the punishment?
Compulsory retirement.
And whether commission has been consulted or not, that is required to be examined by the appellate authority.
My lord, the appellate authority has written that he has examined the inquiry report and
Correct. Whether is it in terms of this sub rule 2 of rule 22? Proviso is there. Proviso to sub rule 2 of rule 22.
yes, my lord.
Provided that the commission shall be consulted in all cases where such consultation is necessary.
Where consultation is necessary, but I think the
Where is the version of the appellate authority that it is not a case for consultation, or has he consulted the commission?
that he has not written, but in
But that we can't presume things. He has to express his in the form of order. Whether is it a matter requires consultation of the commission or not. If it is not, he has to assign the reason. In such cases, the consultation is not required with reference to Article 320 or something.
yes, my lord, they should have been written since
Therefore, we'll set aside and remand the matter to the appellate authority. Appellate authority is will be permitted to pass fresh order in terms of Rule 22 of.
that will be done. Although this is a well-known fact, although I have not thoroughly gone through it. In the case of non-gazetted officers, the consultation with the commission is necessary.
In that event, he must write, no?
Yes, my lord. That would have been.
He has not written. That means there is a non-application of mind. And even discipline. What is the state contention taken in the appeal has not been considered.
Simply, this has been written that he has considered all the.
Merely considering is not sufficient. He is deciding the appeal. He has to assign the reason why he is not considering the contention of the appellant. Where is the disciplinary authority order? Where is the disciplinary authority order?
That is answer 4 at page 56. That is one another flaw, Your Lordship. The appointing authority was general manager, but the order has been passed by the senior medical officer, Your Lordship. So that is one of the grounds.
Where is your order of appointment?
That is not on record, but
Then you can't make a oral statement.
the Learned Tribunal in the impugned order has noted this fact that the 2000 appointment letter was issued by the general manager.
Huh?
This has been explained in the order, beyond the order itself. This has been explained that the junior selection grade officers are the appointing authority, and any senior person may impose
The
penalty.
senior person.
Yes, my lord. Yes,
Senior than the appointed person.
yes, my lord.
Impugned order, page 69. Your Lordship. It's one of the submissions before the tribunal. Page 69. Internal page 3 of the impugned order.
In which paragraph the competency of the appointing authority has been decided?
This has been decided, my lord.
Paragraph 7. Oh, contention.
This is one of the submissions before the tribunal.
This has been decided.
Anyway, appellate authority, we are remanding the matter to the appellate authority. Appellate authority is also hereby directed to examine competency of the disciplinary authority. Take on the appellant, the petitioner has assailed the order of the Central Administrative Tribunal dated 24th May 2016, passed in OA 906 of 2012. The appellant, while working as a Group B employee in the medical wing of the railway department, is alleged to have involved in a illegal demand and acceptance of gratification, a sum of rupees 100 from what is his name?
ORI, ORI.
From ORI, in order to get a sickness certificate from a doctor. Sir. After trap proceedings were completed, petitioner was subjected to disciplinary proceedings and it was concluded imposition of penalty of compulsory retirement on 10/9,
8/9/2008.
8/9/2008.
8.
So, feeling aggrieved and dissatisfied with the order of disciplinary authority, petitioner invoked the remedy of appeal before the appellate authority, and appellate authority affirmed the order of the disciplinary authority on 21/9/2012. Thereafter, petitioner invoked remedy under Section 19 of the Administrative Tribunal Act, 1985, in filing OA number 906 of 2012 for the Central Administrative Tribunal, Patna Bench, Patna, for short CAT. Original application 906 of 2012 was dismissed on 24th May 2016, hence the present writ petition. Learned counsel for the petitioner submitted that the tribunal has not appreciated the not following Vigilance Manual number 704 and 705. It is further submitted that Braj Kishore, shadow witness, has not been examined and cross-examined. It is further submitted that both the disciplinary authority and appellate authority order are not speaking order. The aforesaid issues have not been appreciated by the tribunal. Hence, the order of the tribunal is required to be set aside,
My lords,
while allowing the OA number 906 of 2012. Per contra, and counsel for the respondent resisted the aforesaid contention and submitted that there is no infirmity in the order of the disciplinary, appellate and CAT. It is further submitted that Braj Kishore has not been, para 704 and 705 of Vigilance Manual has been strictly adhered by the Vigilance team. And further, Braj Kishore was not examined as he died before pendency, during pendency of the inquiry proceedings. However, his statement has been taken into consideration. It is further submitted that other witnesses' statement suffice, even though Braj Kishore was not examined in the inquiry. that does not vitiate inquiry proceedings. So it is also submitted that disciplinary and appellate authority need not pass elaborate order in considering each and every issues to heard the land councils for the respective parties. The petitioner was involved in alleged illegal demand and acceptance of illegal gratification from one Ori in the guise of getting a sickness certificate from a doctor to his stuff. In this regard, he was trapped by the vigilance team, and it was subject matter of disciplinary proceedings. Disciplinary proceedings were concluded in imposition of penalty of compulsory retirement, and it was affirmed by the appellate authority. The CAT rejected the petitioner's OA number 906 of 2012 to establish Vigilance Manual para 704 and 75 has been adhered by the concerned authority or not. Is required to be examined by the disciplinary and appellate authority.
My lord, this was examined by the Honorable CAT itself, my lord.
Disciplinary and appellate authority. Full stop. Insofar as the examination and cross-examination of Braj Kishore is concerned, Braj Kishore, that shadow witness, is concerned, he died during the pendency of the inquiry. Therefore, it is impracticable to examine and cross-examine him. Therefore, what is required to be examined is in respect of evidence of other witnesses and material evidences. Therefore, inquiry will not vitiate merely non-examination of a dead person. Please stop. Next one. The Land Council for the appellant petitioner submitted that disciplinary authority order is not a speaking order. To stop. The disciplinary authority order need not be a speaking order. At the same time, if the petitioner had filed his explanation to the inquiring officer's report and in not considering the explanation by the disciplinary authority, in such an event, it would be a non-speaking order. To stop. Annexure 4, page 56. Annexure 4 is the disciplinary authority's order dated 8/9/2008, reads as under. It is on page 56. Similarly, order of the appellate authority is dated 21/9/2012, reads as under. Perusal of the aforesaid orders of the disciplinary and appellate authority is evident that there is a non-application of mind by both the authorities. To stop. Disciplinary authority, in not considering the petitioner's explanation to the inquiring officer on the inquiring officer's report, would defeat the very object of providing second cause notice along with the inquiring officer's report and seeking explanation of the petitioner. Further, the appellate authority has not adhered to Rule 22 of Railway Servants within Discipline and Appeal Rules, 1968. The Rule 22 reads as under. Reading of appellate authority and Rule 22, the sub-rule 2 of Rule 22, it is crystal clear that there is a non-application of mind on behalf of the disciplinary and appellate authority. So, Apex Court in the case of Victoria Memorial held that reasoned order should be passed to stop. Further, in the case of Kranti Associates, para 47, it is held as under. In the light of these facts and circumstances, the petitioner has made out a case. However, the tribunal, CAT, has not appreciated as to whether the disciplinary and appellate authorities order are in terms of relevant rule of rules 1968 or not. Accordingly, Annexure A4, disciplinary authorities ordered dated 8/9/2008, appellate authority order dated 21/9/2012, and CAT order dated so and so passed in OA number so and so are set aside, and matter is remanded to the disciplinary authority to decide the petitioner's case afresh after due consideration of each of the contention raised against the second show cause notice read with the inquiring officer's report. To stop. The above exercise shall be completed within a period of 3 months from the date of receipt of this order. What is the age of the petitioner? Next paragraph. Disciplinary authority is hereby directed to take a decision as to whether the petitioner shall be placed under suspension or he shall be taken back to duty in the light of Apex Court decision in the case of NDECL versus so and so, All India so and so, paragraph 47 to 50 reads as under. To stop. Further, recently Apex Court, the principle laid down in the MDECL has been reiterated in the case of State of Uttar Pradesh versus Prabhat Kumar. Next, the intervening period from the date of compulsory retirement till passing a fresh order by the disciplinary authority is required to be regulated in accordance with the relevant provision of law. In this regard, as necessary, keeping order shall be passed after passing a fresh order in a departmental inquiry within a period of 2 months from the date of passing fresh order. Accordingly, writ petition alone.
Obliged.